Hi, my name is Natalia and I am a real estate attorney here in the state of Florida. And today I want to talk to you about homeowners association liens and tax deeds. So, if you are a person that has invested in a tax deed, meaning you went to the auction held by the tax deed clerk, and you were the winning bidder of a piece of property subject to an association, whether it's a homeowners association, a condominium association, or a commercial association, you've now got to deal with an association and their attorneys and their behaviors and their assessments. And I want you to know your rights as a tax deed recipient when it comes to these particular parties. So, things that you must know when you are a tax deed purchaser and the property that you purchased is subject to an association. Number one, the restrictions, covenants, guidelines of the association that are recorded in the official records survive the issuance of the tax deed. That is to say, you have to abide by those recorded restrictions and obligations. You do not get to ignore it just because your deed is a tax deed and it is considered paramount, brand new title from the state. You will have to abide by the paint color schemes, the approval for roof changes, tenancy requirements, limitations on who you can put in as a tenant if it's a commercial parcel, for example. Those aspects have to be respected. On the other hand, if that association sends you a notice of claim of lien shortly after you've come into the tax deed property, and they are trying to assess or make you pay for any monetary delinquency that came due prior to your tax deed date of issuance, you do not have to pay a dime of that. The Florida statutes definitely make way for those things to be wiped out by the issuance of the tax deed. So those prior monetary obligations that the prior owner had for those delinquencies in assessments or special assessments that were made by the association, those do not have to get paid back. It is very different from acquiring property at a mortgage foreclosure sale, for example, where if you are the purchaser, you have joint and several liability with a prior owner. That is not the case here for homeowners associations. You do not have joint and several liability with a prior owner because your deed is brand new, direct title from the state, and therefore it's as if you do not have a prior owner, and therefore their assessments are completely wiped out. So that is something to keep in mind. Do not pay those. If you get a claim of lien letter, you should go speak to a real estate attorney that can send back communications, call that association as quickly as possible and let them know you will not be paying for any of those assessments. You do not have any legal obligation to pay for those assessments, and please keep those tens of thousands of dollars in your pocket. All right, investors, this is my word of advice for today. It's not actual legal advice, but it is general guidelines. If you are a purchaser at a tax deed sale, of course, the circumstances vary, but when it comes to paying those assessments for homeowners association, if the money came due prior to having the tax deed, you do not have to pay unless the tax deed gets undone. So like I said, facts and circumstances. For now, good luck out there, investors.